Hi, I am Abhilasha Nautiyal and I practice intellectual property law before the Delhi High Court. Today we will talk about the module on well-known trademarks. In this module, we will cover what are well-known trademarks, are well-known trademarks recognized in India. We will also understand the reason why some trademarks are recognized as well-known trademarks and the criteria for recognition of marks as well-known. We will conclude with understanding how such well-known trademarks are enforced and recognized. We will now start with understanding the meaning of well-known trademarks. As you know, brands are important and they are omnipresent today. Brands have value to consumers because we prefer different brands differently. Brands also have value to the supplier of the brand. As you know by now, trademark law was chiefly designed to protect the interest of the consumer. Trademark law did so by protecting the consumer from being confused of deceptively similar or identical trademarks that did not come from the proprietor of the mark. This is known as the sole identification function of a trademark. In addition to this, a brand also is of value for the proprietor of the trademark. But does trademark law protect the interest of the proprietor, or is it always the interest of the consumer? Well-known trademarks and the doctrine of dilution come to the aid of the proprietor. Now, both of these doctrines are of recent origin compared to other settled principles of trademark law. Both can be seen as somewhat of a deviation from the traditional principles of trademark law that seek to protect the interest of the consumer. Now, before we go to the statutory definition of a well-known trademark under the Trademarks Act 1999, let me give you a few examples of what marks have been recognized as well-known trademarks. Benz has been recognized as a well-known trademark. So has the trademark Tata. Now, you would have a brief idea of what kind of trademarks are generally identified as well-known trademarks. Now, section 2 clause 1 clause 2G of the Trademarks Act defines what a well-known trademark is. Let us study this provision to understand the meaning of a well-known trademark in India. This provision provides a mark which has become so to the substantial segment of the public which uses such goods or services or receives such services that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of those services between those goods or services and a person using the mark in relation to the first mentioned goods or services. Now, let us understand this definition by way of an example. A mark, say Mark Tata of Tata Sons Limited, which the substantial segment of the public uses for particular goods or services, is used by another person for other goods or services, say for example by a third party for Tata Diamonds. Now, is this likely to indicate a connection between Tata Sons and Tata Diamonds? In this case, the Delhi High Court answered in the affirmative and said that Tata is a well-known trademark and restrained the use of Tata by unrelated parties for unrelated goods and services. Now, from the definition of a well-known trademark itself, you can see that well-known trademarks are enforced against parties using those marks for unrelated goods and services. For instance, if your mark is registered for say stationery and subsequently your mark is recognized as a well-known trademark, you can actually stop someone from running a hotel under your trademark. Now, this does give far more protection to marks than is traditionally given under trademark law. Now, is this unfair? Should such wide protection be given to trademarks at all? Let us examine why well-known trademarks are recognized to answer this query. Now, the reason why trademarks are recognized as well-known trademarks, there are at least three primary such reasons. Firstly, it is to prevent unfair use of a mark's reputation. Secondly, to prevent harm to the reputation of a trademark. And lastly, obviously, to prevent consumer confusion. Now, we will go through each of these reasons to actually understand why such great protection is accorded to some trademarks. As you know, some marks do enjoy greater reputation than others. I will explain this point by way of an example. Now, this example is actually a case that was decided in 1994. What happened was the Benz tristar logo, which is recognized worldwide, was used by a party in India for unrelated goods. Now, this party in India was obviously not making cars or selling components that were used with cars or even giving services that were vaguely related to cars. This party was using the Benz tristar on undergarments. Now, under traditional trademark law principles, such use would be permitted. If Benz did not have a registration for the tristar logo in the relevant class, which is for undergarments, then Benz could not have restrained this third party from using its Benz tristar logo. But it was held that such use would amount to infringement of the well-known trademark, which was the tristar logo, because that tristar logo had great reputation, and this party, the defendant, was actually taking unfair advantage of the great reputation that the tristar logo enjoyed. Now, you can also view this from another angle. When a proprietor invests a lot of effort, time and money in building the reputation of a trademark, is it always fair to let someone else take benefit of that reputation? This is one of the reasons why some marks are recognized as well-known trademarks and are enforced against parties that use them for unrelated goods and services. We will now discuss another reason why some trademarks are given the special status of a well-known trademark, that is to prevent harm to the reputation of a trademark. Let us understand this point by way of an example. Consider the trademark Tata. Now, Tata is a well-known trademark in India and consumers associate it with a group of companies. What happens if a party starts using Tata in a derogatory manner? To answer this further, let us examine the doctrine of dilution. A doctrine of dilution is a way of enforcing well-known trademarks. There are two aspects to the doctrine of dilution. First is dilution by blurring and second is dilution by tarnishment. We will first understand the meaning of dilution by blurring. Dilution by blurring is basically what the name suggests. It is dilution of the reputation of a trademark when several other parties start using it, causing the reputation of the trademark to blur. The second aspect of the doctrine of dilution is dilution by tarnishment. Now, this is a case where a famous trademark may be used by another party in a derogatory manner. Now, in this case, the derogatory use of a famous trademark may lead to harm to the reputation of the famous trademark. Hence, a famous trademark may be protected by enforcing the doctrine of tarnishment. These are another reason why some trademarks are recognized as well-known trademarks. And lastly, some marks are recognized as well-known trademarks to avoid consumer confusion. You may recall this is the protection that is accorded to all trademarks. In the case of well-known trademarks, they are accorded additional protection, which is they may be enforced against use of similar or identical trademarks for unrelated goods and services. And the primary reason why they are given this additional protection is to protect their reputation. Now that we have understood why some trademarks are given broader protection and are recognized as well-known trademarks, let us understand what is the criteria for recognizing a trademark as a well-known trademark. Interestingly, the Trademarks Act does not set any criteria for courts to consider to decide while deciding when is a trademark well known. However, the Trademarks Act does provide criteria that the registrar of trademarks may consider while determining when a mark is well known. This criteria is provided in section 11 of the Trademarks Act. Let us go through the relevant provision of the Trademarks Act to understand the criteria that is set out in it. Under section 11, there are at least 5 factors that the registrar of trademarks may consider while deciding if a mark is well known or not. We must understand that the status of a well known trademark gives wide protection to the said mark. Hence, it is in limited circumstances only that such recognition must be accorded to a mark. The first factor provided under section 11 of the Trademarks Act is the knowledge or recognition of that mark in the relevant section of the public, including knowledge in India obtained as a result of promotion of the trademark. The section further provides several factors that may be considered in this regard. Firstly, the number of actual or potential consumers of the goods or services. Secondly, the number of persons involved in the channels of distribution of these goods or services. And thirdly, the business circles dealing with the goods or services to which that mark applies. So, the first criteria set for recognition of a well-known trademark is the knowledge or recognition of that mark that it enjoys in India. Second factor listed in section 11 for recognition of a trademark as a well-known trademark is the duration, extent and geographical area of any use of that trademark. The third criteria listed is the duration, extent and geographical area of any promotion of that trademark, including advertising or publicity and presentation at fairs, etc. The fourth criteria for recognition of a mark as a well-known trademark is the duration and geographic area of any registration of or any application for registration of that trademark under the Indian Trademarks Act to the extent they reflect the use or recognition of that trademark. And lastly, the record of successful enforcement of the rights in that trademark, in particular the extent to which the trademark has been recognized as a well-known trademark by any court or registrar under that record. Now, while these factors are only guidelines that the registrar of trademarks may follow and are no way exhaustive or mandatory, they provide the general principles of recognizing a trademark as a well-known trademark. Now, the Trademarks Act specifically lists out certain factors that are not required for recognition of a mark as a well-known trademark. There are at least 5 factors that are listed in the Trademarks Act as a word of caution to the registrar to not consider mandatory when determining whether a trademark is a well-known trademark. The first such factor is that the mark has been used in India. Now, the basis for putting this factor is easily understood. There are several trademarks that enjoy a wide reputation globally but may not have any actual use in India. Such marks can still be recognized as well-known trademarks in India, since use in India is not a prerequisite for such recognition. The second such factor is that the mark has been registered. Now, this factor benefits trademarks that have wide reputation, proprietors of which enjoy common law rights but do not have registrations in India. The third factor is that the application for registration of the trademark has been filed in India. Now, this factor does suggest that well-known trademark status can be accorded irrespective of any application for registration in India. And lastly, that the trademark is well known or has been registered in or in respect of which an application for registration has been filed in any jurisdiction other than India, or that the trademark is well known to the public at large in India. So, after reading the relevant provisions of the Trademarks Act, it does become clear that there are some guidelines specifically prescribed for the Registrar of Trademarks to follow, and these guidelines focus on the reputation of a trademark before recognizing it as a well-known trademark, because after all, it is that specific reputation that a trademark enjoys which gives it the benefit of the status of a well-known trademark. As I had explained earlier, there is no set criteria set under the Trademarks Act for courts to follow. Well, section 11 does act as a guideline even for courts, and this is the reason why courts have developed very similar criteria for recognizing a trademark as a well-known trademark. Again, the criteria set out by courts revolve around factors, concrete proof, evidence that can show and establish the reputation of a trademark in India. This criteria, as explained in section 11, states the knowledge or recognition of that trademark in the relevant section of the public, including knowledge in India, obtained as a result of promotion of the trademark. Now, you will see that this factor takes into account the wide promotion that a trademark proprietor may engage into, as this is a factor that will directly indicate the reputation of the trademark in India. The Trademarks Act under section 11 further clarifies what additional factors may be considered with respect to the knowledge or recognition of a trademark in India. Now, these factors include the number of actual or potential consumers of the goods or services, the number of persons involved in the channels of distribution of the goods or services, and the business circles dealing with the goods or services to which the trademark applies. The second criteria for recognizing a trademark as a well-known trademark under the Trademarks Act is the duration, extent and geographic area of use of that mark. So, we first considered the knowledge and recognition of the trademark by consumers, and the second factor pertains to the use of the trademark. Again, you will see how both of these factors help us understand the reputation of a trademark in India. The third factor under section 11 is the duration, extent and geographical area of any promotion of that trademark. Here you will notice the slight overlap between the first criteria and the third criteria, both of which deal with promotion of the trademark. This also includes advertising, publicity and presentation at fairs or exhibition of the goods or services under the trademark in question. The fourth factor under section 11 for recognizing a trademark as a well-known trademark is the duration and geographical area of any registration of or any application for registration of that trademark under the Indian Trademarks Act, to the extent they reflect the use or recognition of that trademark. Now, how would a trademark application or registration reflect the use or recognition of that trademark in India? One factor, as you would know, is the use claimed in a trademark application by the proprietor. This may also show the long use of a trademark in India by the proprietor. The fifth factor under section 11 that may guide a registrar of trademarks in holding a trademark as well known is the recordal of successful enforcement of the rights in the trademark, in particular the extent to which the trademark has been recognized as a well-known trademark by any court or registrar. Now, these 5 factors that we just studied may seem to suggest that a trademark must be used in India, or that trademark must be registered in India, or in fact the trademark must already be recognized as a well-known trademark before the registrar of trademark can accord it the special status of a well-known mark. That is actually not the case. Section 11 clause 9 of the Trademarks Act clarifies that there are certain factors which are not prerequisites for a recognition of a trademark as a well-known trademark. Yes, they may be important, but they are not prerequisites for recognition of a mark as well-known. These factors are that the trademark has been used in India. As we already discussed, some trademarks enjoy reputation in India without them being actually used. This is also relevant to the concept of trans-border reputation of a trademark. Trans-border reputation of a trademark means the reputation of a trademark that travels across borders of countries wherein a mark enjoys reputation in countries where it is not registered. You may recall that trademark registration gives territorial rights only, and by showing trans-border reputation, it may be argued that a mark enjoys well-known reputation in India even in the absence of any use of that mark in India. The second factor that the Trademarks Act cautions us against is that the trademark has been registered. Again, it may be helpful while arguing a case on whether a mark is well known in India to say that the mark is already registered, but it is not a prerequisite for such registration. The third factor that we are cautioned for is that an application for registration of the trademark has been filed in India. Again, this is not a prerequisite. Fourthly, that the trademark is well known in or has been registered, or in respect of which an application for registration has been filed in any jurisdiction other than India. Again, it is not a prerequisite to have a well-known status from another jurisdiction, or to actually have registrations in other countries, or to have at least filed trademark applications in other countries. Now, all of these factors seem to suggest that reputation will be protected in a trademark even in the absence of a registration or application for the same trademark in India or abroad. And lastly, that the trademark is well known to the public at large in India. Now, this is a very interesting factor that section 11 clause 9 cautions us for. It says that the trademark may not be well known to the public at large in India. Now, let us understand this with the first requisite or the first factor under section 11 that we had discussed earlier for recognition of a mark as well known, which was knowledge or recognition by the specific segment of public. A reading of these two provisions where it is provided that it's knowledge of a specific segment of public and not the public at large, which is relevant for deciding whether a trademark is well known in India. Of course, it will be helpful if a trademark is recognized across sections of the society, but it is again not a prerequisite. Now, I had earlier mentioned that there are no specific guidelines for courts, there are no specific provisions in the Trademarks Act for courts to follow when deciding a trademark is well known. However, courts have developed over a period of time principles that they consider when they are deciding whether to accord the status of a well known mark to any mark. Now, these principles naturally are very similar to the principles set in the Trademarks Act for the Registrar of Trademarks. Now, the Delhi High Court in the case of Tata Sons versus Manoj Dodia laid down a few factors. I will quickly summarize those factors for your understanding, but you will also notice the striking similarity of these factors with those in the Trademarks Act. In this case, factors such as the extent of knowledge of the mark II and its recognition by the relevant public, duration of the use of the mark, the extent of the products and services in relation to which the mark is being used, the method, frequency, extent and duration of advertising and promotion of the mark, geographical extent of the trading area in which the mark is used, the state of registration of that mark, the volume of business of goods or services sold under the mark, the nature and extent of use of same or similar mark by other parties, the extent of actual enforcement by courts of the said mark, and actual or potential number of persons consuming goods or services being sold under the brand were listed as factors that may be considered while deciding the well-known status of a mark. One such factor is the nature and extent of the use of the same or similar mark by other parties. While we may not have a great detailed understanding of what this point refers to, but it may seem a little contradictory to the doctrine of blurring we discussed a while ago. As you may recall, blurring prohibits unauthorized third-party use of a well-known trademark. But the courts have now said that third-party use of a trademark which is unauthorized may be relevant to determining whether a trademark is well-known or not in the first instance. Now, this gets us to another practical point on how are trademarks recognized as well-known. Do you file an application for such a declaration? Do you approach the courts? Let's understand how this aspect is dealt with. Now, even if a court recognizes a trademark as well-known, what happens after that? Is it an automatic generation of a well-known status even before the registrar of trademarks? Practically, after a court gives a declaration of a well-known mark, the proprietor moves an application before the trademarks registrar, who then records the status of the mark as well-known in the register. Now, we discussed, yes, there are benefits to recognition of a trademark as well-known, but how is a well-known trademark enforced and these benefits realized by the proprietor of the trademark? For a registered trademark that is declared well-known, Section 29 Clause 4 of the Trademarks Act is relevant. Now, while Section 29 Clause 4 does not specifically refer to well-known marks, it refers to only marks with reputation. Hence, recordal of well-known status is not mandatory when enforcing a mark under Section 29 Clause 4. Section 29 Clause 4 may also be seen as embodying the doctrine of dilution in India. Let us quickly study Section 29 Clause 4 of the Trademarks Act. This section provides that a registered trademark is infringed by a person who is not an authorized user of the trademark when it is used in goods or services which are not similar as those for the registered trademark, and the registered trademark has a reputation in India, and the use of the mark without due cause takes unfair advantage or is detrimental to the distinctive character or repute of the registered trademark. Here you will see that the doctrine of dilution is codified under Section 29 Clause 4 of the Trademarks Act. I must end with a word of caution. Trademarks that are recognized as well-known enjoy far greater protection than others, and in some cases of abuse may lead to stifling of public expression, freedom of speech. Therefore, it is only in cases where a trademark is fit to be recognized as a well-known trademark should such status be granted. I will now summarize today's module on well-known trademarks. We started with understanding the meaning of what a well-known trademark is, both generally and under the Indian Trademarks Act. We then understood the reason why some trademarks are given this special protection. After that, we understood the criteria which is considered while recognizing a trademark as well-known. Now that we have understood the ammunition a well-known status can accord a trademark, I will end with a word of caution. Because well-known trademarks give far more protection to trademarks than other trademarks are accorded, it is important to give such protection only to worthy trademarks. Otherwise, this will lead to a chilling effect in the market, where any use of a mark for unrelated goods or services will be curbed. It is also important to understand that such great protection may also stifle public expression or parody of a trademark. Thank you.